All right, some breaking news for you. A judge has released the Fulton County Special Grand Jury's full report on interference into the 2020 election in Georgia. The jury heard from dozens of witnesses before recommending charges last December to District Attorney Fani Willis. Now, Nicole Killian's joining us now to explain kind of the report. It just got released, so everyone's trying to sort of dig in and get the key components of it. But before we even go down that road, I just want to clarify what this is, because there was a grand jury but also a special grand jury. So tell us, the difference between the two and which report this is.
Well, just to be clear, this was actually a special purpose grand jury, which was more or less an investigative body. Obviously, as we know, shortly after that phone call that former President Trump had with Georgia's Secretary of State Brad Raffensperger in January of 2021, where he asked him to find him the votes to potentially overturn the election in his favor. Shortly thereafter, District Attorney Fani Willis launched an investigation. And then in 2022, that is when
Welcome in, everybody. This is Dr. John. A dramatic headline claims a grand jury has accessed sealed records promising Trump's long-awaited reckoning. The anticipation is real, but whether the reality matches the hype remains to be seen. But here's the thing about those headlines. They're designed to make you feel that way. They're crafted with surgical precision to trigger exactly that emotional response. The language is chosen specifically to create a sense of urgency, drama, and impending doom for one side while delivering vindication to the other. The headlines are optimized for clicks, for shares, for that dopamine hit of seeing a powerful figure finally face consequences. And there's nothing inherently wrong with that. Media outlets need to get attention. They need people to read their stories.
This special purpose grand jury was impaneled. And so they heard from a variety of witnesses, upwards of 75 witnesses, ranging from, for instance, Rudy Giuliani and other top aides and associates of former President Trump, Senator Lindsey Graham of South Carolina, for example, along with a number of others. And so this special purpose grand jury was convened for a period of months where, again, they heard a lot of evidence in this case and ultimately produced a report at the end of that process, where we are now learning, based on the report that was released today, this final report, that they did recommend indictments against a number of individuals, some of whom were named in the recent indictment against the former president and those 19 co-defendants. So, for instance, they did, with respect to that call with Secretary of State Brad Raffensperger, they did recommend an indictment for the former president, for Rudy Giuliani. But there are also a few names in here that were not part of that indictment. For instance, Cleta Mitchell, who was another member of the former president's legal team. Again, we're still kind of going through this to see what other names might be in here. But
what happens when the dramatic headline doesn't actually match what's happening in the courtroom? What happens when the legal reality is far more complicated, far more incremental, and far less cinematic than the headline suggests? That's where things get interesting. That's where the gap between perception and reality creates a fundamental misunderstanding of how the American legal system actually works. Something complicated happens in a courtroom. A judge signs an order that moves a legal process forward in some incremental procedural way. Maybe it's a ruling about what documents can be shared with whom. Maybe it's a decision about how much of a grand jury transcript can be disclosed to Congress. Maybe it's a narrow interpretation of an exception to the general rule of grand jury secrecy. These are the kinds of rulings that legal professionals spend their careers analyzing.
That is really what is interesting about this report, because it kind of lets us know this is what the special purpose grand jury recommended to the district attorney with respect to indictments. Of course, now that she has indicted 19 individuals, we're now looking at this report to see whether the district attorney kind of followed that guidance and those recommendations that were made by this special purpose grand jury.
So, as we are telling everyone, this was just released, so you're kind of skimming it right now and giving us the highlights that are jumping out at you. One of our reporters, Graham Cates, also going through it and was, nice enough to kind of pull out some important bits for us. The grand jury overwhelmingly voted to recommend the indictment of Donald Trump, quote, with respect to the January 2nd, or January, I think maybe 24th, I'm not sure. We're talking about the 2021 phone call from President Trump to Secretary of State Brad Raffensperger. So, we can remind viewers about that phone call because that phone call really did seem like a smoking gun. I mean, he calls up the Secretary of State and says exactly how many votes he would like them to find.
They're important. They have real consequences for the cases they're part of. But they're also tedious, procedural, and deeply unsexy. They don't lend themselves to dramatic headlines about worst nightmares and grand jury victories. And yet, almost inevitably, some version of that headline appears. A grand jury wins access to sealed records. Trump's worst nightmare. The walls are closing in. Accountability is finally arriving in a flood of previously hidden and secret documents. The language is designed to make you feel like you're watching a movie climax, like the hero has finally cornered the villain, like the truth is about to pour out in a dramatic cascade that will change everything. But here's the reality that the headline leaves out.
Well, right. And obviously, as we pointed out earlier, this was really kind of what launched and spearheaded this investigation by the district attorney. And as I mentioned, they did, in fact, make this recommendation based on that specific phone call to indict the former president as well as others. But, some people do see that as a smoking gun. But, the former president and his team have argued that he did nothing wrong, that this was a perfect phone call in his view, and that he had a right to contest the election, and that's all that he was doing here. So, there is a difference of opinion here. Obviously, he was indicted in part not just for this call, but as we know, this investigation really was sprawling and went well beyond this call. This also involves, for instance, people like Rudy Giuliani, who testified before Georgia state officials, basically spewing out a lot of purported falsehoods about the election, that thousands of dead people voted in Georgia, that, ballots were illegally stuffed in suitcases and weren't properly counted. And so ultimately, again, we saw Giuliani and others indicted for.
Grand juries don't win access to sealed records. They don't compete for documents. They don't have opponents they're defeating in a contest. That's not how any of this works. What the headline is actually describing, when you strip away all the dramatic language, is a far more mundane and procedural legal reality. A judge applying a specific legal standard to a specific set of facts authorized a specific narrow disclosure of specific grand jury materials to a specific party for a specific purpose. That's it. That's the actual thing that happened. And it happens all the time in courtrooms across America. It's not a worst nightmare. It's a Tuesday. But understanding why that gap exists,
purportedly making false statements to Georgia state officials. So not only was about this call, it was about pressuring other state officials. Also, this involves, a separate incident in a small rural county in Georgia where there was a breach of voting equipment in a small rural county called Coffee County. So again, all of this is part of this broader investigation, which again is part of this evidence that the special purpose grand jury heard, and again, ultimately resulted in that indictment we saw last month of 19 individuals.
And so just to give people a sense of what we are hoping to find out as we continue to dig through this document is the kind of information that I just spoke about, how the members of the grand jury felt about the behavior. Are we talking about split decisions or overwhelming decisions in one way or another? And in this case, the grand jury overwhelmingly voted in favor of indicting Donald Trump. And Graham writes, 6 relevant statutes were cited, all with votes that included just one of up to 22 voters.
Why the headlines sound so different from the legal reality requires understanding the legal framework that governs grand jury secrecy in the first place. And that framework, the system of rules and precedents that has developed over centuries of American jurisprudence, is actually fascinating in its own right. It's worth understanding, not just because it helps you see through misleading headlines, but because it reveals something important about how our legal system balances competing interests. Secrecy versus transparency. Investigative integrity versus public accountability. The need to protect the innocent versus the need to hold the powerful accountable. These are the tensions that grand jury secrecy rules are designed to manage. And the way courts handle those tensions tells us a lot about what kind of legal system we have. Let's start at the beginning. Grand jury proceedings are secret by law. That's not an accident or a loophole that someone can exploit. It's the foundational rule that governs everything else. When federal prosecutors convene a grand jury to investigate whether criminal charges should be brought, every single thing that happens in that room is protected by law. The witnesses who testify, the documents that are subpoenaed, the exhibits that are reviewed, the deliberations of the jurors, the decision to indict or not to indict, all of it is covered by grand jury secrecy rules that are among the strongest protections in the entire American legal system. And those protections exist for reasons that have been recognized for centuries. They protect people who are investigated but never charged from having their reputations destroyed by mere suspicion. They protect witnesses who might be intimidated or retaliated against if their testimony were known publicly. They protect the integrity of the investigation itself by keeping targets from coordinating their stories or destroying evidence before charges are filed. These are serious, legitimate, structural reasons for the secrecy. It's not arbitrary. It's not a conspiracy. It's a considered legal judgment that the public interest is better served by keeping grand jury proceedings confidential in most circumstances. Now, the law also recognizes that there are limited situations where disclosing grand jury materials might be appropriate. Those exceptions are governed by Rule 6E of the Federal Rules of Criminal Procedure. This is the master rule that controls everything about grand jury secrecy. It says that no one who participates in a grand jury proceeding can disclose anything that was revealed before the grand jury. The rule covers grand jury testimony, grand jury documents, and even information about who testified or when they testified. Violations of Rule 6E are criminal contempt of court. That's how serious the secrecy is. But Rule 6E also allows courts to authorize disclosure in narrow, specific circumstances, like when disclosure is necessary for a criminal proceeding in another jurisdiction, or when a government attorney needs to share information with foreign governments under international agreements, or when Congress can demonstrate a specific need for the materials in connection with a legitimate legislative purpose. But these exceptions are genuinely narrow. Courts interpret them strictly because the default rule is secrecy. The system is built to keep this stuff closed unless there's a very specific, very justified reason to open it. When a headline says a grand jury wins access to sealed records, it's describing something that simply does not match how the legal system actually works. It's either describing a court authorizing a specific narrow disclosure, which is not the same as a grand jury winning access to anything, or it's describing something that didn't happen at all. And in the Trump legal landscape, the actual documented record shows courts mostly keeping sealed records sealed, sometimes with explicit language that they will stay sealed for now and perhaps indefinitely. The worst nightmare framing is pretty much the opposite of what courts have actually been doing. Let's go deeper into this, because there are several specific documented legal proceedings involving Trump and grand jury records that are worth understanding clearly. Each one tells a slightly different story about how these access battles actually play out in the real legal system. Start with the Mueller materials. This is one of the most documented examples of how grand jury access actually plays out in the Trump legal context. After the Mueller investigation concluded, the House Judiciary Committee wanted access to certain grand jury materials from the investigation. The committee argued it needed those materials to carry out its impeachment-related responsibilities. The legal fight over those materials ran through the courts for years. Eventually, a D.C. Circuit panel ruled that the House could access some of the Mueller grand jury materials in the context of the first impeachment inquiry. But here's what's genuinely important to understand about that ruling. It was not a grand jury winning access to sealed records. It was a court authorizing a specific, narrow disclosure to Congress based on a specific finding that Congress had demonstrated a legitimate, particularized need for those materials in connection with its impeachment authority. The court determined that the constitutional authority of Congress to impeach is sufficiently analogous to a judicial proceeding to justify disclosure under Rule 6E. That's a complex and specifically argued legal theory. The authorization was limited to the specific materials relevant to the specific impeachment inquiry. It was not an open door to all Mueller grand jury materials for any purpose. And it was the court that made that determination, not any party winning a contest. The judge evaluated the legal arguments on both sides and issued a ruling. That's the mechanism. That's how it always works. And that's nothing like a grand jury winning access to sealed records. Then there's the Epstein grand jury material dispute. In 2025, the DOJ sought to unseal certain Epstein grand jury transcripts. That effort created its own complicated series of court proceedings. On one side, you had arguments that public interest in the Epstein case and the identities of potential co-conspirators who were never charged justified broader disclosure. On the other side, you had arguments that grand jury secrecy protections exist precisely to protect people who are investigated but never charged, and that unsatisfied public curiosity is not a sufficient legal justification for overriding those protections. Courts issued mixed rulings. Some specific materials were authorized for limited release. Others were kept sealed with the language that they would remain protected for now and perhaps indefinitely. The process was messy, contested, and incremental. Nothing like a grand jury winning access to sealed records. More like a slow, contested court proceeding with no clear winner and no dramatic worst nightmare moment. And then there's the 2022 sealed search warrant matter connected to Trump. When courts were dealing with questions about the grand jury investigation underlying the Mar-a-Lago search, there were specific fights over which materials could be disclosed and under what circumstances. The D.C. court authorized only a limited disclosure of specific grand jury materials in that context, not general access to everything, not a grand jury winning access to sealed records. A narrowly tailored court order authorizing specific disclosure for specific purposes. That's always the pattern, always. Because the system is designed to work that way. The secrecy is the rule. The disclosure is the exception that requires specific justification for specific materials. This is why the specific misframing matters. The grand jury wins access framing implies that grand jury proceedings operate like adversarial contests, where one side wins and another loses. The grand jury wins, and when the grand jury wins, Trump loses. His worst nightmare arrives. That framing suggests a clear loser and a clear moment of defeat. But grand jury proceedings are not adversarial contests between the grand jury and the target of an investigation in the same sense that a trial is. A grand jury is convened to evaluate evidence and determine whether charges are warranted. It does not compete against anyone. Its job is to evaluate. And the secrecy around its proceedings is not a shield the target has erected to prevent the grand jury from seeing things. It's the default legal protection that courts enforce regardless of who wants what. When courts do authorize disclosure of grand jury materials, it's because a specific legal exception has been met. And when they deny disclosure, it's because that exception has not been met. Neither outcome is a grand jury winning or losing. Both are courts applying a specific legal standard to a specific set of facts. Let's also talk about who actually controls sealed records and why that matters for understanding these headlines. In the American legal system, sealed records are sealed by court order. They can only be unsealed by court order. Parties can file motions asking courts to unseal specific records for specific reasons. Courts evaluate those motions under the applicable legal standards. They grant them when the standard is met and deny them when it's not. The parties cannot themselves unseal records. The prosecutor cannot unseal records on their own. Congress cannot unseal records on their own. A grand jury cannot unseal records on its own. Only a judge can do it. And judges do it narrowly and specifically when they do it at all. So when a headline says a grand jury wins access to sealed records, it's attributing agency and control to an institution that does not have that kind of independent agency over its own access to records. The grand jury does not walk into a vault and take things. A court evaluates a legal request and issues an order. That's a completely different thing. And understanding that difference is the difference between following a legal story accurately and being misled by dramatic language that does not match how the law actually functions. Let's break this all the way down and be completely clear about what's actually happening in these cases. Grand juries do not win access to sealed records. Courts decide what gets disclosed and what stays sealed, and they decide it narrowly. Let's be absolutely clear about this from the ground up. A grand jury is a group of citizens convened by a court to evaluate evidence in a criminal investigation. They hear testimony that prosecutors present to them. They review documents that prosecutors bring before them. They ask questions. They deliberate. They decide whether to issue an indictment or a no-bill finding. They operate under the direction of the court and the prosecution. They do not independently pursue records. They do not file legal motions seeking access to materials that are sealed in other proceedings. They do not have their own legal standing to petition courts for disclosure of sealed materials from separate cases. They do not win or lose access battles. They do not have opposing counsel or a judge awarding them something they competed for. When a court authorizes disclosure of grand jury materials, it's because a party with legal standing, usually the prosecution, a government agency, Congress, or another party who can demonstrate a particularized need under Rule 6E, filed a motion asking for that authorization and demonstrated that their specific situation met one of the recognized exceptions. The court then evaluated that showing against the legal standard and issued a ruling granting or denying the request. That is the actual mechanism in every single case. It is completely different from the framing of a grand jury winning access to anything. The agency is in the court and in the party seeking disclosure, not in the grand jury itself. And that distinction matters. Every time you encounter a headline that frames legal proceedings as a contest with winners and losers who are accumulating records and defeating their opponents in dramatic courtroom victories. In the actual documented Trump-related grand jury matters, courts have mostly kept sealed records sealed. This is the part that is almost the opposite of what the worst nightmare headline implies. The documented pattern in Trump-related grand jury matters is that courts have generally kept things sealed, sometimes with explicit language saying they will stay sealed for now and perhaps indefinitely. The DC court that handled various Trump grand jury matters kept significant amounts of material sealed, emphasizing that the default presumption of secrecy under Rule 6E is strong and that overriding it requires a specific and compelling legal justification. The Mueller materials disclosure to Congress was a notable exception, but even that was narrow, specific, and limited to impeachment-related purposes. The Epstein grand jury transcript fights produced mixed results, with some materials authorized for limited release and others kept sealed. The Mar-a-Lago search warrant grand jury matter produced only narrow, limited disclosure of specific materials. In none of these cases did a grand jury win access to sealed records in the way the headline implies. The pattern is courts carefully managing narrow exceptions to a strong secrecy rule, not grand juries gaining broad access to sealed Trump records and producing a worse nightmare outcome. The real legal story around Trump and grand jury records involves a genuine and significant constitutional debate that deserves serious attention on its own terms. The battles over disclosure of grand jury materials in the Trump legal context have produced genuinely important legal precedents and genuinely difficult constitutional questions that will continue to matter long after individual cases are resolved. When Congress sought the Mueller grand jury materials, the court had to grapple with the relationship between the grand jury's constitutional role, the executive branch's interest in secrecy as a matter of institutional design, and Congress's oversight and impeachment authority as a co-equal branch. Those are not small questions. They are fundamental questions about how the constitutional system allocates power between the branches of government. And the answers courts give to those questions establish precedent that applies in future disputes including disputes that have nothing to do with Trump specifically, but that involve the same structural tensions. The Epstein grand jury fights raise different but equally significant questions. Does public interest in matters of high historical and legal importance ever justify broader disclosure than the narrow Rule 6e exceptions would normally allow? Do the victims of the subject of an investigation have standing to seek disclosure of materials that might identify others who were involved? Those are legitimate and genuinely complex legal debates with serious arguments on multiple sides. They involve real courts issuing real rulings with real legal significance for how grand jury secrecy will function in future high-profile cases. And they deserve to be covered as the constitutional and procedural disputes they actually are, with the complexity and care that those disputes require. Not as worst nightmare moments where a grand jury wins access and Trump loses in a dramatic accountability cascade. The real story is actually fascinating and consequential for American legal history. The fictional version just replaces a complex constitutional debate with a simple sports match narrative that does not match what the courts are actually doing in the actual proceedings. Understanding how sealed records actually work is a critical skill for anyone trying to follow the Trump legal story accurately. When you see a headline about sealed records, grand jury access, or disclosure rulings in Trump-related cases, ask 3 specific questions. First, who is actually seeking the disclosure and on what legal basis? If it's a court authorizing narrow, specific disclosure to a specific party for a specific purpose, that's very different from a sweeping, dramatic access ruling. Second, what specifically is being disclosed to whom and for what purpose? Grand jury material disclosures are almost always narrow and targeted. If a headline makes it sound like a broad flood of documents, that's a signal the framing is exaggerated. Third, is there any court language about the scope and limitations of the disclosure? Courts that authorize even limited grand jury disclosures typically say explicitly that the authorization is narrow and does not set a precedent for broader access. If the headline is not mentioning those limitations, that's a signal that important context is being left out. Apply those 3 questions to every sealed records headline you see, not just in Trump cases, but in any high-profile case where legal process is being described in dramatic terms. The 3 questions will almost always reveal that the real story is narrower, more procedural, and more significant in a constitutional sense than the worst nightmare framing can capture. Grand juries do not win access to sealed records in the way this headline implies. Courts control what gets disclosed and what stays sealed under specific legal standards that start from a strong presumption of secrecy and allow only narrow exceptions when a specific legal justification has been demonstrated. The actual documented pattern in Trump-related grand jury matters has been mostly continued sealing with narrow exceptions authorized for specific purposes in specific contexts. The Mueller materials disclosure to Congress was real and significant, but narrowly tailored and based on a specific constitutional theory about impeachment authority. The Epstein grand jury fights produced mixed results with some limited disclosure and more materials kept sealed. The Mar-a-Lago search warrant grand jury matter produced only narrow, limited disclosure. In none of those cases did a grand jury win access to sealed records and produce a worst nightmare outcome for Trump in the dramatic sense the headline implies. The legal battles around disclosure of Trump-related grand jury materials are genuinely significant constitutional questions about Rule 6e, the balance between grand jury secrecy and competing public and institutional interests, and the allocation of power between branches of government. Those questions deserve serious and accurate coverage that explains what courts are actually doing, rather than framing narrow procedural rulings as victory moments in an adversarial contest. The real story is interesting and important. The fictional version just makes it sound like a sports match where grand juries are winning rounds and Trump is losing them, when the actual process is far more slow, procedural, and judicial than any headline can capture. And once you understand how sealed records actually work, you will never read one of these headlines the same way again. The truth is far more nuanced, far more fascinating, and far more revealing about how American democracy actually functions than any dramatic headline could ever capture.